All right, so a happy Sunday and good morning to everybody, and thank you for joining us today, Sunday morning, early 9:30. And I know I got some messages about perhaps some people were supposed to be in church now. So if you're supposed to be in church, go to church. This is not as important. You'll be able to catch it later on the replay. So if you're able to do that beforehand or last night or whatever it is, then I appreciate it. I did not mean to conflict with your religious, needs. But if you are all here, so then we all appreciate that very much. And I see that the chat's already getting pretty full. I see there's some questions already. Put the questions in there. We'll get to them eventually, I think. Hopefully, to the end. But I really want to first concentrate on just the back and forth and conversation that I want to have with brother Counsel. But definitely, you can definitely put the questions in, and hopefully we'll get to them near in the middle of the show or the end of the show, or when there's a nice natural break. Hopefully we'll get to that. Okay, so definitely put them in, put the question marks there, and we'll get to them. Okay, now, although it's 9:30, and I know I'm sorry that we're starting so early, but Solomon's got a very busy week ahead of him, and it was actually pretty nice of him that he was able to cut out this time for us. A lot of it is because a lot of pressure that I put on him to make sure that this works. So he was able to make it work at 9:30 in the morning. So I very much appreciate him being able to squeeze this in. I know that as soon as we're done, he is taken off probably for the week. And but maybe we'll get him again next week. So I have my ways of exerting pressure in different ways. So without any further ado, let's bring Solomon onto the stage, and he can give a shout out to whoever he wants. Good morning, Solomon.
Good morning, brother Counsel. How are you on this fine Sunday morning?
Good. I'm doing amazing. We had a great weekend. Just coming off of a little bit of a cold. Maybe you heard in my voice. But thank you so much for making the time. I know that you have a busy week ahead of you, and I think everyone's going to appreciate your perspective. They always do. So really appreciate you, cutting out some time for us.
Absolutely. And by the way, before we get started, I just want to say a quick hello to Lori, to Allie Lori. She's a friend of an attorney against whom I just tried a case a couple of weeks ago, and from what I understand, she's a big fan of the show.
Oh, okay, great. Well, thank you for that, Allie. And also before we get into so there's a few things we want to talk about. Obviously, we're going to talk a lot about what happened in the first week in Karen Reed, but I do know that over the weekend there was a lot of buzz about this affidavit. So I just want to spend just a couple minutes on this affidavit. We're not going to spend a lot of time of it, and the reason is that Solomon, you and I both know affidavits get filed every other day in court. There's people putting their names to all types of things, and this specific affidavit was filed in Turtle Boy's case. It wasn't filed in the Karen Reed case. There's a lot of very spicy allegations in there, a lot of allegations of corruption, allegations of wrongdoing and misconduct and things like that. And I would just caution everybody that before you start running with this affidavit and assuming everything in this affidavit is 100% true, we do have a process in place here in America. There's something called due process. Everybody gets it, whether you like the person or whether they don't. An affidavit is just that, an affidavit. It should put the issue in front of the court. And if the court, when they see the allegations, they feel that there's some credibility behind it, perhaps they'll have an evidentiary hearing. They'll have some sort of hearing in court about it. We'll get people on the stand, and we'll get a lot more clarity into exactly all the allegations, what type of information they actually knew, what they didn't know, and things like that. So I would just say, yeah, it looks pretty crazy, the affidavit, but I would just caution everybody that before you start running away with this affidavit, assuming everything in there is 100% true without hearing anything else, I would just caution you against doing that. Solomon, any quick thoughts about that affidavit?
I'll tell you this. Anytime you see an affidavit like this that makes these kinds of allegations, you got to take it with at least a grain of salt, if not a couple of grains of salt. The allegations are definitely extreme. I would expect that if there's this kind of explicit corruption going on, there would be some sort of documentary evidence supporting it, whether it's emails, text messages, recorded phone calls, recordings of interactions. Without some sort of documentary evidence actually supporting these kinds of claims, I wouldn't read too much into it. That's just generally what I could tell you about an affidavit like this. Plus, we don't know who signed it.
Yeah, I mean, we don't know who it is. It was filed in Turtle Boy's court case, and I'd like to see an evidentiary hearing. Let's put some people on the stand, and then we'll actually get some answers to some of these questions. So, yeah, it looks pretty crazy. And then, like Solomon, that you don't just put anything in an affidavit. There are some specific allegations, very, very specific, that someone's signing their name to. So, that obviously does hold some level of credibility in the court, but it's not everything. And you should just be careful. And let's wait to see how more information comes out as a result of this affidavit being filed. Just don't jump onto that ship 100% just quite yet. I would just caution everybody about that. So let's let the process play out. That's why we have a court system. Let's let it play out, and let's see how it ends up, coming up. Okay. So Solomon, I've been covering this case for the past week. I know you've been incredibly busy the past week. I know you just finished up a trial, which you were very successful on. You're moving on to new things. So I did send you the opening statements, and I did a video on the opening statements. I pointed out some of my thoughts, my feelings about it. So why don't you give everybody that I'm assuming you got a chance to look through the opening statements and watch them, maybe on double speed or whatever it was, but let us know what your thoughts are. Tell us about Hank Brennan. Tell us the good, the bad, the ugly. Tell us about Alan Jackson. Tell us about maybe some mistakes each person made. I mean, what you have done different. Go ahead. Just take it away.
Okay, so just to kind of give you an outline of what my general thoughts were in real time as I was watching them, I try very hard when I look at opening statements to put myself in the place of the jury, hearing things and seeing things for the first time and wondering how I would view this. Obviously, this as a trial lawyer. It's incredibly important to be able to do that and to be able to look at something dispassionately without any emotion and just try to ask yourself, how would a reasonable, intelligent person view this? So as I was watching these in real time, I'll tell you this. I was watching Hank Brennan. I thought he did an absolutely excellent job. There were a few things that I thought he did just perfectly. And I probably would have given him a 10 out of 10 just after watching his opening statement. Is this freezing? Because it looks like the footage is freezing. I don't know why.
Yeah, I think it's
okay?
Yeah, we can hear you fine. I think just your camera's freezing a little bit, but go ahead.
Okay. But then I heard Alan Jackson's opening statement, and I got to tell you, the contrast of not only the narrative and the storyline, but of the evidence that was discussed, I think was tremendous. And I think the prosecutor made a big tactical error by not addressing some of those points head on. For example, I don't believe Hank Brennan said the name Michael Proctor. I don't think he addressed that text message. There's a lot of things that were obviously going to be discussed by the defense in the opening. And what you don't want when you're the plaintiff or the prosecutor in this case, when you go first, you have the opportunity to present facts however you want. What I like to do, and I heard this from a mentor of mine who I think is probably the most successful trial lawyer of all time, at least that I know of. His name is Mark Lanier. He says what you do is you take all the facts that you have in a case and you put them into two columns, good facts and bad facts. And then what you do is you take all the bad facts from the bad fact column and move them into the good fact column. Somehow you figure out a way to do it, because otherwise they're going to hear those facts from the other side presented in a way that the other side wants them to be presented. And when that's the case, you're kind of running a risk of looking like a liar. If you don't present all the facts, if you leave out a very important fact, then the first thing the defense is going to do is say, hey, you know what the prosecutor or the plaintiff forgot to tell you? Let me tell you what they forgot to tell you. And right off the bat, it's going to look like the defense is being honest and the prosecutor's not. And I think Hank Brennan made a big tactical error. Now, Hank Brennan has been doing this for a long time. I'm sure he knows what he's doing. I'm sure he thought of the things that I'm saying and disagrees with me. I'm just telling you from my perspective and my analysis of this is he made a big mistake by not addressing things that he knew the defense would talk about. Okay, like for example, I'll give you a perfect example. I just tried a prisoner civil rights case. Okay. The very first thing I tell the jury anytime I have a prisoner civil rights case is my client is a prisoner. He's there in prison because he did something wrong. Get it out there. There's no reason not to. There's no reason not to address it. And if there's something bad that the jury's going to hear, you've got to be the one to say it. If the prosecutor knows that this Michael Proctor text message is going to come in, you've got to address it. And the fact that he didn't, I think, cost him a lot of credibility with the jury. So that's just kind of from 30,000 feet. If you want to get into the details and the weeds of each opening statement, I can. Or if you have any specific points you want to ask me about, obviously I can do that as well. Up to you. But can I just ask you for a favor? Can I log out and log back in, because this footage is driving me nuts?
Yeah, I don't know why your camera's a little bit shaking out.
Okay.
So yeah, I'll remove you. Okay, so we're just taking, he'll sign back out, stand back in, and see what happens there. But yeah, very similar to what I was saying to you guys also about the opening statements. What Solomon was echoing essentially is that if there's a bad fact, you gotta embrace it. I mean, that's just what you have to do in opening statements. You gotta embrace the bad facts. You gotta tell the jury your spin on it, why it's not really a bad fact for you, why it's really a good fact, and if it's a bad fact, why it doesn't really destroy your case and why it doesn't destroy you winning the case. So that was essentially a big part of what he was saying. Let's see if we can bring it back, Solomon. Okay, you're back. Right. Hopefully you'll be better this time.
Hopefully.
Okay, so if not, we can still hear your audio completely clear. If anybody has problems hearing him, they'll let me know in the chat. But it seems like your audio is 100% fine. Now I think the video is a little bit better now. Also,
but the video's better. Yeah.
Okay, so first of all, okay, so you're going to have to tell everybody, because you have to understand that there's a lot of people out there who really are on the Karen Reed side. We call them the free Karen Reed people. And a lot of times anything that the other side does, they automatically say is bad, terrible. And I myself have been finding myself sometimes sticking up for Hank Brennan, saying that, no, he's actually an attorney that knows what he's doing. And he's not just some idiot attorney. And, people don't always like that because they're just very, very on the side of Karen Reed. So you said that you saw his opening statement and there were some good parts to it. And obviously I see the chat. Some people are saying, oh, how can you say there's anything good about Hank Brennan? So why don't you tell everybody what you thought was good about Hank Brennan's opening statement?
Okay. So here's, let me say it this way. Okay. Because I'm sure the first question people are going to ask is, how can you present a bad fact in a good way? The way you do it is you come up with the best way to present it without gaslighting somebody, and you hit it head on. Okay. The way that I think Hank Brennan should have done this in a case like this, or any lawyer should do it in a case where you've got a material witness, perhaps one of the most material witnesses, with a very bad text message that you know is going to come in. You've got to put that in. You've got to be the one to tell the jury about it. If you can't figure out a way to make it good and to try to twist it and somehow try to explain it, then what you got to do is you got to say, now, ladies and gentlemen, I'm going to be completely honest with you. You're going to see a text message that says this. But don't lose sight of the full picture here, and then focus on everything else. Focus on all the evidence that you think does support a guilty verdict in this case, if you're Hank Brennan. And then when the defense gets up and tells you about Michael Proctor in the text message, the jury's like, yeah, we know that already. Tell us something we don't know. That's the thing. So whether it can be, because I said there's the two columns, whether you can literally take every bad fact and turn it into a good fact, you've got to figure out a way to do it. You've got to figure out a way to at least present those facts as best as you possibly can. Okay, so that's again just from a very high level. Were you going to say something?
Yeah, no, I'm just saying. Tell us the good parts. I mean,
okay. The good parts are, and I kind of was taking notes as I was watching both opening statements. I'll tell you what I got for Hank Brennan. He did a very nice job making it a chronological story. He said it like a story. It was like a narrative of what happened. You always want to be able to tell the jury a story. On April 14th, 2017, Mr. Jones was driving down the street, and it was a beautiful sunny day, and he felt the sunshine on his skin. And as he was you want to make it as much of a story as possible. And I think he did a very good job with that. I think he did an excellent job humanizing John O'Keefe. Ultimately, this case is about the murder of somebody, the tragic death of John O'Keefe. And he did a very nice job humanizing him, I think. He presented the EMS witness who's going to say, I hit him, as an unassailable hero, which of course is something you want to do. Something that everybody does, whether they know it or not, when you're presenting a case, is something called the halo effect. When you're presenting a case, you're going to kind of give the jury enough to make conclusions. And you want them to agree with you, and you want them to kind of put the halo around certain people and put the devil horns on other people. And if you tell them right off the bat, this guy's a liar, this guy's the devil, this guy's beautiful and perfect and amazing, the first thing the jury's going to say is, yeah, prove it to me. But if you kind of explain it in ways that they can understand, like describing this person as an unassailable hero, who does EMS and has no dog in the fight. And then the jury kind of on their own, and I think people listening and watching will automatically kind of put the halo on them and then say, well, yeah, this person's probably telling the truth, right? Because he or she is a good person. I think that Hank Brennan did an excellent job describing the scene in graphic detail. He relied on cell phone data and on the science. He kept referring to the science and saying that the case is about science. He referred to the cell phone data, the temperature of the cell phone, medical data, and he kept referring to the science. And he kept saying how the case is about science. Now, it's a strong point. It could also be a little bit dangerous because he knows that this case has a lot of circumstantial evidence. He knows that there's going to be a lot of bad evidence that comes in. And so it's kind of risky doing it that way. But that's what he did. And I thought he did a fine job with it. The way that a very important thing that he did, which I thought he did an excellent job, was when he told the jury right from the beginning, we will not prove that she intentionally killed him. It's a murder trial. The jury is going to implicitly think that she intentionally murdered him. That's what the prosecutor has to prove. By getting out in front of that, and I'll tell you right now, if he would not have said that, it's something that Alan Jackson probably would have said in his. They will not be able to prove that she intentionally murdered anybody because they know they can't prove that. So Hank Brennan kind of got in front of that by saying, that's not what we're going to prove. That's not how this works. It's not that kind of charge. So that was, I think, a very important point. And as he was wrapping it up, he closed with a very strong statement. This case will come down to the science and the data. Now, again, in your opening statement, if you know you've got the science and the data to back it up, good. Make such a bold statement. If you're not going to be able to back that up, it's very dangerous to make a bold statement like that, because then in closings, the defense attorney is going to say, remember when Mr. Brennan told you this? Remember Mr. Brennan told you that this case comes down to science and data? But it turns out it doesn't come down to that at all. It only comes down to he said and she said and a whole bunch of very questionable claims that are being made, and the science goes both ways, or the science is more strongly in our favor. And now he's arguing circumstantial evidence and testimony. So it's a little bit of a dangerous claim to make. It's a very bold claim to make. But again, if you know you've got what it takes to back it up, go for it. Do it. And then I'll tell you the last thing, and this is just I thought it was very, very powerful until I saw Alan Jackson's opening statement. But when Hank Brennan played the clip of Karen Reed talking to the media, I think it was a Dateline interview or a 60 Minutes interview? It was some sort of interview.
That was a Dateline. I think that was Dateline.
Okay, and it was a clip, and obviously when you just have a clip, a risk of playing a clip is if there's other statements that are going to come in that kind of soften it up. I'll give you an example. I had a case one time where an attorney showed the jury 3 lines of testimony that my client said. I said, look at how much of a liar he is, or she is. And then in my rebuttal, what I did was I got up and I said, let's look at the next 3 lines. And it completely changes the story and make the other attorney look like a liar. Very dangerous to show little clips to kind of, get the point that you want to get across. But I will tell you this, letting your client talk to the media is very risky. It's something that I usually don't let my clients do. I've had a number of cases that were in the media. It's almost all of them have been civil. But when it comes to civil cases, I'll do the talking because it can't be used against my client. Certainly in a criminal case, I don't think I've ever let my clients talk to the media when it's a criminal case, because it's really, really risky, really risky. Yeah, so, all it takes is one slip of the tongue, and now the jury's going to hear whatever it is that they're going to hear.
That's something that we're seeing in this case already. We already see Hank Brennan strategically playing clips at certain times of the trial. People have been asking me, well, he's allowed to play the clips whenever he wants. And I said, yeah, they're exhibits. There's stipulation to the exhibits, and he has the choice to do the order of evidence whenever he wants. So yeah, he can start playing certain clips at certain points, which is going to bring us to a certain clip, which I'm going to play for you shortly. But before we get to the clips, there's a few clips I want to play for you actually. But so that was your take on Hank Brennan. I also thought that, I mean, I didn't show you this. I didn't show you what Adam Lally's opening statement looked like. But if you would compare between Adam Lally and Hank Brennan, I think you would see very clearly the stark difference between Adam Lally and Hank Brennan, and definitely in terms of the storytelling. And you and I both know about how important is storytelling, as you've already told everybody. But Hank Brennan absolutely did a much better job about saying over a story. And I also thought about this because this is something that, you know, you and I think about also when we're trying cases, is that, okay, we know we're going to say a story, but from whose perspective do you say the story over? Do you say it over from Karen Reed's perspective? Do you say it over from John O'Keefe's perspective? Do you say it over from John O'Keefe's mother? Do you say it over from, you know, like there's so many different people to choose to say the perspective of the story over. And I thought this was an interesting way that he chose the paramedic who got the call at 6 a.m., who's going to be argued that he's a completely independent, objective, not involved in the whole powerful Albert family and everything like that. And he's just a paramedic showing up for the job. And he's the one who eventually the story ends with Karen Reed telling him, I hit him. So I think that was a strategic move by him. And I think that part, like you said, I think was very good because it said a story. It ended up with a confession. Essentially what he's going to argue is a confession. So then Let's get into Alan Jackson's opening statement and tell me what you liked, and tell me about if you think that there's any sort of over-promising that you may have felt that maybe he shouldn't have done.
Well, we're not going to know, or at least I'm not going to know about the over-promising issue until, you know, the rest of the case plays out. But what I can tell you, just if I'd be a juror watching both of these opening statements, I'll tell you what I thought about Jackson. First of all, he started with the 3 rule, the rule of 3s. This is something that I've seen a lot of excellent trial lawyers do. There's 2 ways that I like to try every case. My opening line to the jury every time will be, this is a simple case.
Well, that's after you say that your client's in prison.
Well, yeah. Well, I usually do that during voir dire, but because you got to get in front of that. But yes, in my opening, I'll do that as well. But you always want to start, I think, ladies and gentlemen, this is a very simple case. It's simple factually and it's simple legally. And then you come up with, you know, maybe a 3 or 4 sentence. So it's like one kind of run-on sentence where you kind of give the jury the nuts and bolts of what you're going to tell them. This is what the case is about. This is what we're going to show you. This is what we're going to prove. This is what the evidence is going to establish. And then you kind of go into the detail. There's either that, and then there's also the rule of 3s, which is this case is about 3 things, A, B, C, 1, 2, 3. And if you notice, you'll see that a lot of things in life, there's a rule of 3. There's, you know, let's count to 3. The 3 Stooges, the 3 Musketeers, the 3 Little Pigs. You constantly see 3. You don't very often see 2 or 4 or 5. 3 is kind of the number that we have in our heads for something that makes sense. So right off the bat, I like that he did that. He also addressed the science and the data head on, and he let everybody know the science and the data are going to be on our side. It's important to do that because when you do that, you're telling the jury right from the beginning, they're claiming the science and data on their side. We're claiming it's on our side. That's what this case is going to be about. You want to let the jury know, what do we agree on? What do we disagree on? The science and data are on our side. Very important to do that, and he did that. He ultimately said, and I thought this was a very strong statement, that the case is based on an assertion that is contrary to science because there was no collision. And he hit on that multiple times. There was no collision. And again, this is something that I think Hank Brennan could have and should have anticipated and didn't. Like, for example, if you know that there's no marks on the body that would be indicative of a car hitting it, then it's something that you would want to address if you're going to try to convince the jury that the car hit John O'Keefe's body. Ultimately, he kind of looked at the jury and said, why are we here? Why is Karen Reed facing a murder charge? And he addressed this beautifully. And he addressed this with something that, like I said before, Hank Brennan did not address, and that's Michael Proctor's text message, which is incredibly damning against the prosecution. It's a very, very rough text message for them to get over. And the fact that Hank Brennan left it out entirely, I think, kind of indicates to the jury that the prosecution's afraid of it because they know it's bad. Instead of saying, you're going to see this text message, you're going to hear this text message, here's why she's guilty anyway. There's something that he did which I think was very risky, which is he said the evidence is going to prove a cover-up. It's essentially what he did. It's a very dangerous theory to go with. Sometimes it's necessary. Juries don't want to believe, nobody wants to believe that police are inherently corrupt or are intentionally covering up a crime. And if that's the theory you're going to go with, you better be able to back it up. Now, I think that given this text message from Michael Proctor, and then obviously how Alan Jackson goes on about the Albert family, I think is obviously a very strong way of doing that, and kind of gives them the right, so to speak, to do that. But when you tell the jury from the very beginning there's going to be a cover-up, and we're going to show you that, you're kind of setting a very high bar for yourself. Again, if you know you're going to be able to reach it, go ahead and set that bar, but it's a very risky bar to set. It's kind of like juries are almost always deferential to the judge. And I know you and I have talked about the one story I have with that one judge where I told the jury to kind of disregard the judge. It's generally a very dangerous thing to do. Juries like to defer to the judge. Juries like to believe that cops are generally honest and good people, make mistakes sometimes, maybe exaggerate something here and there, but to engage in an actual corrupt cover-up is a high hurdle. The way that he describes the scene in detail, I thought was excellent. He made it he kind of brought the jury there. He described the screaming, the police, the firefighters, and then meanwhile, the police officer who lives in the house never went outside, who's also a first responder from what I understand. It's a very bad fact that, again, something that Hank Brennan left out that I think he probably should have gotten in front of, because if you know that all this is going on in front of your house and you're dealing with somebody who's a law enforcement officer, and you know that Alan Jackson's entire case is going to be about how corrupt this family is, you want to get in front of it. But Hank Brennan didn't do that. Obviously, he thought about it and chose not to. He said that Michael Proctor never went into the house. In conjunction with that text message, I think is very, very strong. I think it highlights the fact that that Karen Reed never should have been charged, because very often juries like to say if somebody's charged, there's probably a reason for that. There was an indictment, there's police, there's pretrial motions. Very often juries think that if somebody's sitting in the defendant chair, he or she probably belongs there. That's just something that I think juries inherently think walking into the courtroom. He even, and this is in my notes, I don't remember him doing that, he told the jury that Hank Brennan purposely left Michael Proctor out of his opening. Now, that is a very powerful thing to do, all right? Because when you directly look across the room and challenge the other attorney, you're like I said, you're setting the stage. Okay, why'd you do that? And I'll do this sometimes in a closing. As a plaintiff, we close, then the defense goes, and then we go one more time. So what I'll do is, if I'm the plaintiff in a case, is I'll get up and I'll say, maybe the defense attorney can explain to us this. And then I'll even turn to the defense attorney and say, can you please explain to the jury A, B, and C? Because I still don't know the answer to that. And then it kind of challenges them. And not only does it challenge them head on, like almost to a duel, but it also throws them out of their rhythm, because now they almost feel compelled to respond to what you're doing. And that kind of throws out, they've got notes and they've got PowerPoints and all kinds of things. And it kind of challenges them. And I think it's a very strong thing that he did. He explains why Karen got charged. And he also suggests who the real suspect is and why the real suspect was never investigated. And that kind of goes to the whole theory of the case, which is police corruption and Michael Proctor. And again, I thought he did an excellent job doing that. When somebody's innocent, a very important thing to be able to do is tell the jury who's the real suspect, or why is this person not guilty? Why is this person sitting here and not somebody else? And I thought Alan Jackson did an excellent job doing that. He refers to the Albert family as the powerful Albert family. He says when they were drinking, the powerful Albert family was already there and they were already drunk and had been drinking for quite some time. And then he describes in detail how connected and powerful the Albert family is, which again, very powerful move. If you're going to start telling the jury about how dirty this family is, you got to have the goods on them. And I think he did an excellent job taking the jury down that path and showing them everything. He describes a video that shows Karen Reed and John O'Keefe happy. And that again is something which was ignored apparently by the police and by the prosecutor and not mentioned in Hank Brennan's opening statement. The video between Brian Higgins and O'Keefe and this interaction or attempted interaction between Brian Higgins and Karen Reed, again, if you're the prosecutor and you know that that's going to come out, you've got to address that head on. The fact that Hank Brennan did not do that, I think, cost him a lot of credibility and gave Alan Jackson a lot of credibility. The opening statements is all about credibility. And I thought, as excellent of a job as I thought Hank Brennan did after watching his opening, that's kind of how excellent, even more excellent of a job I thought Alan Jackson did.
Yeah. He didn't talk about the butt dials either. The phone calls at 2
right.
o'clock.
He didn't talk about the butt dials. Right. I'm going to get to that as well. The fact that there was no bruising consistent with being hit by a car, Hank Brennan completely left that out. Alan Jackson hit that, head on. He pointed out that everybody left and supposedly John O'Keefe's body is lying there and everybody walked past it. Makes no sense. There's literally no explanation for that. Again, if you're Hank Brennan, you've got to explain that. Ladies and gentlemen, all of these people walked past John's body. Here's why they didn't see him. You've got to address that. There's just no way to present this case without addressing that. And Hank Brennan left that out. And I think when Alan Jackson did that, he kind of created a lot of questions. Question marks are good when you're the defense in a case because all you need is reasonable doubt. So his suggestion, Alan Jackson's suggestion that the body was moved and then brought outside, again, I thought was very strong. The snowplow driver testimony that he referred to, very, very powerful. And again, something that Hank Brennan left out. If you know there's going to be a snowplow driver and there's going to be, that was, I think, at 2:30 in the morning, and then testimony of the Ford Edge being there at 3:30 in the morning, you've got to address that. Otherwise, the jury is just going to hear it from Alan Jackson, the way that Alan Jackson wanted them to hear it. Now, it's possible that Hank Brennan knows that he's got no case. It's possible. I don't think he'd be trying this case if he didn't think that she was guilty. I really don't think that. I'd like to think that both sides believe in their case, at least the attorneys. But that's, I don't understand why Hank Brennan didn't address that head on. Again, he's an excellent attorney. He knows what he's doing. But to leave all this stuff out and let Alan Jackson be the one to gain the credibility with the jury, to tell the jury about all these things in a way that he wants the jury to hear about it was very, I think, not well done by Hank Brennan. The fact that Albert and Higgins both got rid of their phones it's a real problem. It's a real problem for the prosecution. You want to talk about consciousness of guilt, and I know the prosecutor loves to say every time Karen Reed sneezes that it's consciousness of guilt. You know what consciousness of guilt is? Getting rid of your phone while there's a police investigation going into a murder. That's consciousness of guilt. Okay. The Google search, "Haas long to die in cold," which was done at 2:27 a.m. And I know there's going to be an expert saying it happened at 6 a.m. It's one or the other. Okay. And I know how this technology works. I've had plenty of cell phone dump cases where I've seen dumps from cell phones that show these things. We're going to know what time. By the time the experts are done, we're going to know what time that search was done. It was either done at 2:27 or it was done at 6 a.m. That's all there is to it. This is not like a medical disagreement about.
Yeah, but that's something that Hank Brennan didn't talk about.
Didn't talk about it at all. He let Alan Jackson be the one to bring it out, and he let Alan Jackson gain credibility about that. The dog that got rehomed, the house that they got rid of and sold. All those things are things that I think show more consciousness of guilt than Karen Reed ever showed, or certainly in Hank Brennan's opening statement about claiming of what Karen Reed did wrong. The rear tail light information. Again, that's the fact that there were 46 pieces found after Michael Proctor gained access to the vehicle.
And none before. You got to be kidding me. I mean, first of all, if that gets shown, that chronologically that's really what happened, I guarantee you Alan Jackson's going to make a big deal about that. And the fact that he was the one that showed the jury that, and Hank Brennan completely left that out, knowing the jury would see it, I think was a tremendous tactical error by Hank Brennan. Yeah. The fact that he addresses the I hit him, and by addressing right out the gate, Hank Brennan kind of relies on that from this unassailable hero. And at the time, I thought he did a good job with that. But if it's not in any reports, you got to address that too. You got to wonder, why isn't this in any reports? And again, that's something that Alan Jackson was able to present to the jury the way that he wanted to, which is this was obviously fabricated. That's why it's not in any reports. This wasn't concocted until months or years later, after everybody had a chance to talk things over.
So, and then something that I thought he did an unbelievable job is when you're giving an opening or a closing, something that you want to be able to do as a lawyer is let the jury finish your sentence, even though they're not allowed to talk. And that's why I kind of like if you have a situation where a drunk driving accident and you're representing somebody who got injured and you describe the scene and there's somebody driving drunk down the road and he was partying all night and his blood alcohol content is 0.27 and he's driving a truck and he's not paying attention and he's texting, and you kind of go into all the detail, and then you describe your client driving up the road with his family, singing along, Sesame Street with his kids in the car, and then it's almost, as the cars get closer and closer, you don't even have to say what happened next. The jury already knows. And a very powerful move by an attorney is to be able to say something to the effect of, do I even have to tell you what happened next? Right? Now, Alan Jackson, I think, did that in his own unique way, which was when he referred to the detective. He said, the only time that I hit him, that was only ever created after an EMT statement taken by Detective Kevin Albert. Long pause. Albert. Okay. Again, the jury's kind of getting along the same thing. Then he says another one. Marie McLaughlin is years long close friends with Caitlin. Long pause. Albert. Michael Proctor is close friends with, long pause, the Alberts. And it almost gets to the point where the jury's like, yeah, we see what's going on here. We see what's happening. And as far as putting those devil horns and the halo on somebody, he may have not been able to put a halo around Karen Reed, but I thought Alan Jackson did an unbelievable job putting devil horns on Michael Proctor and on the Albert family. And the fact that John O'Keefe's body was found right in front of the Alberts' home is a real problem for them, a real problem. Another thing that I thought was very powerful, another thing that Hank Brennan left out that Alan Jackson jumped on, was that John's shoe had 5 other males' DNA on it.
Yeah.
The fact that you have DNA on people, and you tell me, because you're more familiar with the case, did the police ever try to get the DNA of the other people who were in the home to see if it matched the DNA on the shoe?
Oh, I don't even think they gave DNA swabs. I don't even think they did.
Well, did they ever ask for that?
I don't think it came out. I don't think there was any mention of that in the last trial. So I don't even think they did.
Well, then again, another major tactical error, I think, by Hank Brennan, and a very, very strong move by Alan Jackson. Ultimately, if you were asking me to grade, after I watched just Hank Brennan's, I told you I would have given him 10 out of 10. After I watch Alan Jackson, I would give Alan Jackson definitely a 10 out of 10. But I'd go back and I would change, Hank Brennan to like a 6.5 or a 7. Because he still did a very strong job presenting his case. But I think he made some very, very big tactical errors. And things that I don't know if he's going to be able to overcome in this trial. Because as these things come out and as these things come to light, the jury's going to remember them. Is this a case? Is the judge allowing the jury to take notes in this case?
Yeah, they're allowed to take notes, but not during opening statements or closing arguments.
Oh, okay. Well, all right. Now, I will say one last thing that you're not going to like. The judge, to her credit, did not give an opening statement. So,
okay, let's get to some comments, and then we'll move on to the clips that I want to show you. So here's a comment from Helene Lewis. Good morning, brothers. Karen Reed's attorneys had to have known she was doing all those interviews, and her words could be used against her. Do you think this is a part of their strategy at this point, although arguably not a good one? Okay,
my answer to that is this. I'd be very, very, very surprised if she spoke to the media without discussing with her attorneys, whether she told her attorneys, I am going to talk to the media, give me pointers, or may I talk to the media? Look, as the lawyer on a case like this, I don't think I'd let her talk to the media. The only time you want to let your client talk to the media is if you know that they are so unbelievably likable and come across as so truthful that nothing bad can happen as a result of them talking to the media. But in a case like this, I would not let her talk. I can do the talking. The lawyer can do the talking. I would not let her do the talking. Was it part of the strategy? I would think probably, but I don't think it was very prudent.
Yeah, and Solomon, and you and I both know that you can take someone's 100% truthful statement and a good lawyer will be able to figure out a way to make it look like the person's trying to hide something or make it, lying or something. So
yeah, but this is different. There was way too much that was left out of Hank Brennan's opening statement.
Yeah, I'm talking about her statements, her interviews to the.
Yeah. That can always be taken out of context. That's why if you're going to show a clip, you got to kind of put it into context too. And if you know there's going to be something else that's said, like that's something that Alan Jackson addressed head on and explained. You're going to see the rest of this clip. That's a trick. That's like what I was just telling you before about where the defense attorney showed 3 lines of my client's testimony and I showed them the other 3 lines.
Yeah. Okay, let's move on to this comment here. Imagine my disappointment when I thought this episode was yesterday and was actually today. Love your content and brothers' insights from fellow Michigander. We have a fellow Michigander with her. This is what KC says about the affidavits. Turtle Boy mentioned in his live she may been undercover. She may have been undercover. She may have been undercover.
She may have been undercover.
Beto has receipts. Turtle Boy and Beto is Turtle Boy's attorney. Beto has receipts. Turtle Boy and Beto don't file anything without receipts.
If they've got receipts for this, they've got a real problem for the prosecutor. Big time.
Yeah. Okay.
If they could support the allegations being made in this affidavit, that's huge. That's a game changer.
Right. I mean, but I think it's still a little premature to start jumping onto that ship just quite yet. So I think we still have to kind of be a little bit more patient out there and see how that all plays out. Okay. So we got Linda said, BC, are you covering the arc of voir dire tomorrow? Of course. Of course I'm covering them tomorrow. That's one of the most important parts of the case. So definitely join us tomorrow for the live. Salman's going to be out of town, but I'll still be here. So yeah, we're going to be doing the live on the trial tomorrow morning and then ARCA experts in the afternoon.
What do you think the judge is going to do?
Well, you got to see. I mean, look, Salman, there's like 100 or something text messages that were between Alan Jackson and the ARCA experts, which were deleted.
It's a real problem.
Okay. So, that doesn't look good, right? The other Karen, your thoughts on Brennan not mentioning Proctor? I think you pretty much went over this pretty well, Salman. You don't think it's a great idea?
Terrible. I think it cost him the most amount of credibility by not mentioning Proctor in that text message. There's a lot of things that I think Hank Brennan should have done better. But leaving out Michael Proctor, not mentioning his name, not mentioning that text message, very, very big strategic mistake, in my opinion.
Yeah, tremendous mistake, I think. And now all the jury's thinking about, no matter what type of evidence gets put on there, they're just thinking, I wonder when Proctor's taking the stand. Right. And what else is the prosecutor not telling me? What else is the prosecutor hiding from me? That's what they're thinking, I think. Amy's Positive Pathway says, good morning, brother Counsel ×2 and the chat. Thank you very much for that. And we have Helene Lewis again. Appreciate your comments and enjoy your channel greatly. Just want to thank you again for your time and coverage. Well, I appreciate that. I hope you're all appreciating this. Okay, now I want to move on before we get to more comments. I want to play you some clips. Now, some of the clips are just going to be some cross-examination, which some of the times I actually like laugh out loud watching the cross-examination because I enjoy a good cross. And then we're going to move on to the clip that is Karen Reed speaking. But first, I want to kind of show you some cross-examination, just 2 clips. So just be patient a little bit, Salman. Just take, your thoughts. And then after I'm done with these 2 clips, then you'll give me your thoughts about cross-examination and these techniques and any other things you have to add. Okay, so this is where David Yannetti, one of the attorneys from Karen Reed, is cross-examining Daniel Whitley. Daniel Whitley was one of the paramedics who responded to Karen Reed, actually, because Karen Reed got called for a Section 12. She had to be taken to the hospital because she had some comments about perhaps hurting herself or harming herself. So he responded to that, and he was going to take her to the hospital. And he said that she made some comments to him about how long someone could survive outside in the cold. Okay, and there's some changes in his testimony. But let's just take a look at this clip just for cross-examination purposes, and then just hold on. I'm going to forward it to another part of the clip also. Okay, so here's one.
And your memory of what happened at the hospital was very good in April of 2022, right?
As good as today?
Your memory in April of 2022 was very good, wasn't it?
It was very good as it is today.
Okay, so you want to add the as it is today, despite the fact that you weren't asked that question. Is that right?
Gotcha.
Okay, so that's just number one, and then we'll move on to because I know, Solomon, you always have these with witnesses that don't want to be answer questions that weren't asked. So let's move on to a little bit more. Just one more clip that I want to show you. And then we'll get your take on both of these. Okay.
And that was the first time that you mentioned that she said, supposedly, or asked supposedly, about him sitting outside in the snow, correct?
I was just using phrases generally speaking.
Not my
I wasn't at that point I was paraphrasing. I was not speaking verbatim to what she said.
Let's try that again. That was the first time that you mentioned that she claimed or asked that he was sitting outside, correct?
It could have been sitting, laying, being.
Let's try it a third time.
So
Was that-
just ask the question, not let's try it.
Sure.
Let's try it.
Was that the first time that you testified under oath that Ms. Reed said or asked about him sitting outside?
Are you asking me to clarify whether she used the
I'm not
word
asking you
sitting?
to clarify anything. I'm asking you whether that was the first time yesterday during direct examination that you mentioned that you asked about him sitting outside.
I'm sorry. I am very confused because I'm trying to figure out if he was being outside, sitting outside.
I'm asking you about Ms. Reed's statements, sir. That's all I've been asking you about. Her
Okay.
statement.
Okay, Solomon. So tell me your thoughts about some of that cross-examination. Let's try this for a third time. So tell me about that, what you thought, and then I'm going to tell you what this judge does with cross-examination.
Okay, well, I'll tell you right off the bat. I don't think he comes across as somebody who's trying to answer questions truthfully and honestly. There's a jury instruction specifically on point that says when you consider credibility, think about whether or not the witness appeared to sincerely be trying to answer questions, or if he or she was arguing with lawyers and trying to dance around the answers. I mean, if you're asked a simple question, give a simple answer. What's your favorite color? Is blue your favorite color? I don't want to hear an explanation about colors and what you think of all the colors. Is blue your favorite color? It's a yes or no. If you have a lot to say about that, obviously, does it show consciousness of guilt? Let's talk about that again, right? I mean, the prosecutor loves using that term. I'd use that term a lot if I were the defense in this, because the prosecutor keeps using it. And every time, a witness like this is refusing to answer a question, I may even say something like that to him. Is your refusal based on consciousness of guilt? Is your refusal to answer my question based on No, the judge probably will interject and not allow him to answer, ask that. But I didn't hear anything yet from the judge that was inappropriate. Let's try for a third time. Judges will reel that kind of stuff in. Sometimes on cross-examination, they'll let you do a little bit of that, to kind of get your questions out. If it could be aggressive, it can be, as long as it's not badgering and as long as you're not attacking the witness too hard, it's cross-examination. Judges will often allow attorneys to engage in, a meaningful and zealous cross-examination. But I didn't see anything from the judge yet that was improper.
Yeah, right. So from these clips you don't, but I really wanted to find some of the clips here that I just didn't have enough time. But I wanted to let you know that there are some times which I really start to crawl out of my skin when I'm watching, because you know how frustrating it is when you're cross-examining a witness. You ask a specific question and the witness wants to give explanations. The witness wants to qualify their answer. They want to start talking about other things. They want to talk about, other topics and not answer your question. And what we find in this case very often, which really drives me insane, is that there'll be a great question on cross-examination and the witness will start going off on a tangent, talking about whatever the witness wants to talk about. And a lot of times the defense attorney, whoever it is, Yannetti, Jackson, will say, "Excuse me, sir, that wasn't my question." As you just heard David Yannetti say, "That wasn't my question." And a lot of times what the judge will do in this case will say, you asked him a question, he gets to answer the question how he wants. And I thought that that's completely improper. It's inappropriate. This is exactly what cross-examination is for. It's for answering my questions. The witness doesn't get to talk about whatever they want. They have to answer my questions. If on redirect, they want to ask you to explain, they want to ask you other topics. If you want to talk about other things, that's their choice. When I'm asking you a question, you got to answer my question. That's how this works.
Right. So, yeah. So judges kind of go both ways with this. If somebody asks a question and it's, it kind of requires an explanation, judges will allow them to explain. When judges, and I've had judges do both ways, I don't think it's proper for a judge to let somebody go off on a tangent. If I ask a simple yes or no question that could be answered with a yes or no, the judge should not allow them to explain. Now, what I'll do is, if I ask a question and they go off on a tangent and blah, 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 they don't answer it, then what I'll do is with or without the judge's help, I'll follow up. Is there a reason you can't answer that with a yes or a no? And then they'll give an answer of some sort and say, my question to you is this, and you gave a whole explanation. Is there a reason you felt the need to do that explanation instead of answering my question? Well, I'm trying to answer your question. What happens is you're drawing the jury's attention to the fact that they're refusing to answer the question. That's what I think you gain by doing something like that.
Yeah. I've also seen you say, what question are you answering now?
I love doing that. That's something, again, that I got from this mentor of mine who's, I think, a tremendous trial lawyer, Mark Lanier. He does that regularly. And I think it's a very powerful cross-examination move. What question do you think you're answering?
And then they say your question, and they say, well, what was my question?
Yeah. Why don't you repeat it? Well, you were just answering it. Why don't you tell me what it was?
Okay, great. Yeah, so that's just some good parts. I always enjoy some good cross-examination. Now, I want to show you the next clip. Okay, now the next clip I think is very interesting, and it's an important part. And I actually think that the judge maybe have made the wrong ruling on this, allowing this clip in. As you know, as we've been talking about, there's been a lot of interviews and documentaries and docuseries and Dateline appearances that Karen Read went on or appeared for. And Hank Brennan's got all these clips, okay? And he's deciding strategically when to play these clips. So let me just kind of set the stage for before this clip is being played, or when he wanted to play this clip. So Peggy O'Keefe is the mother of John O'Keefe, the victim here, the deceased. And Peggy O'Keefe last trial did not testify. This trial testified. And in this trial, basically what her testimony came down to, aside from talking a little bit about John, was that when Karen came over to the house to gather her belongings that morning, she let her in with her father and her brother. They went upstairs for 10, 15 minutes, and they gathered her stuff, and then they left. And she testified that there was no interaction at all between herself and Karen Read. No talking, no how did this happen, no question, nothing. There's no interactions. So then right after Hank Brennan after she was actually Alan Jackson, you'll appreciate this, on cross-examination, Alan Jackson just got up and said, Mrs. O'Keefe, I'm very sorry for your loss. And then that was the extent of the cross-examination, which I thought was very
brilliant, very powerful. If you don't have questions, don't have questions. You got, and that, by the way, I'll just tell you, anytime you're asking questions to a witness, you have to ask yourself, what point am I trying to make?
Yeah, exactly.
You have to have your bullet points that you want to hit, and if you don't have any, don't ask any questions.
Exactly.
I've done that.
Yeah.
I've had people where I'll just get up and say, I have no questions.
Yeah, exactly. So okay, so then this is the clip that he wanted to play, and watch the clip, and then we'll talk a little bit about the argument about whether he should be allowed to play this clip. All right, here we go.
And his mother leans over the kitchen island and says to me, I think it looks like you got hit by a car. It looks like you got hit by a car.
All right. Well, that's the clip that he wanted to play. Now we know about a defendant's statement.
The she who said that is Peggy O'Keefe?
Yeah.
John's
the
mom.
mother
Okay.
of John O'Keefe. So obviously, you just have this, this older woman who's the mother of this John O'Keefe, who was crying on the stand and said very clearly that she had no interaction with Karen Read, very believable witness. And then you're going to play that clip immediately after, showing Karen Read almost like making fun of her and mimicking her and saying a completely different story. So
Peggy testified or didn't testify?
No, Peggy absolutely testified. Yeah, she testified in this trial. And then right after that testimony, that's what Hank Brennan wanted to play this clip. And there was some argument about this clip. So the first argument that Alan Jackson made is that you can't just call someone for impeachment. That's not allowed in Massachusetts. They have to actually add.
Who's he calling for impeachment?
Well, the argument is that you're essentially calling Karen Read in this or playing this clip from Karen Reed to just impeach Peggy O'Keefe.
I don't think that's a winning argument. What else? What else is there?
That's number one. Number two is that it's irrelevant. There's no reason for that clip to be played. How does that have anything to do with this trial, whether she actually, murdered John O'Keefe by backing her car into him? So Hank Brennan's response was that, well, it shows consciousness of guilt because, your favorite argument, because why does it show consciousness of guilt? Because she's trying to manufacture a story about how other people were coming up with this cockamamie story that she hit him with the car and that she's like the victim here. And now this is where the whole conspiracy or this whole let's charge Karen Reed because of this crazy story is coming up. So he's trying to show that, well, why, she's making up this story kind of to cover her own guilt. So that was the argument. And I'll tell you what Judge Cannoni ruled in a minute, but I want to get your thoughts on it.
Interesting. So let me think about this for a second. So the prosecutor wants to introduce this statement from Karen Reed. Generally, a statement of a party is admissible. The only way it wouldn't be is if there's some other basis, whether it's relevance or hearsay or something else. Peggy did testify, and she testified that she had no interaction. And then now we've got Karen Reed making a statement that, I'm not really sure who's contradicting. I don't see how this helps the prosecutor, frankly. I don't see how this helps the defense either. All this does is it shows that Peggy claims she had no interaction with Karen Reed, and Karen Reed claims that Peggy made a comment to her about how it looks like he got hit by a car. I don't get who this helps in any way. Should it be admitted? Sure. I don't see why not. I don't think it shows consciousness of guilt. I think that's insane. That's just a dumb argument prosecutors make all the time. We already talked about that enough. Does it help anybody? No. I don't think it helps anybody. I don't know.
I don't think
it helps anybody.
I don't think it shows Karen in the greatest light. Like they're playing that to the jury, and she's there, mimicking this older lady who just lost her son, or, like that. That I can see how the jury may not like her. When you don't have your client on the stand, they have no idea what this defendant is like.
Let me ask it this way: why would Karen Reed lie about that? Does she have anything to gain by falsely claiming that Peggy made that statement to her?
Well, to make herself as the victim, perhaps.
How is she making herself the victim?
Because they're, saying that there's this whole crazy story out there that they're thinking that she hit him when there's, no evidence behind it.
That's what I don't understand. Why would, between the two of them, I don't know who's telling the truth. I don't know if this conversation happened. It seems like a pretty dumb thing for her to make up. It doesn't help her in any way.
Yeah, but if that's her theory of the, if that's what the Commonwealth's theory of the case is, where do they come up with this stuff from? Whatever. That's just what that was the argument. There's been a lot of talk about this clip. I thought it shouldn't come in. And Judge Cannoni allowed it in. So the jury saw that, and now we'll see what they're thinking. But that came in, and that's why these type of clips, I don't think it helps her. I don't think any of these clips help her. If anything, the jury can the more they hear from her, they can start developing opinions about her personality or what her type is, and that's not what you want. You don't want them to start making judgments about. You don't put them on the stand and she's just sitting there. She's just sitting there quietly and attentive. That's really what you want the jury to think, nothing more. And they're going to be seeing a lot of clips of her, and they can start developing an opinion about her. So, okay, let's kind of move on. Let's move on. And again, you guys put some questions in the chat. We'll try to get to them. Let me just pull up this thing before we move on to the next topic. Already emails from Julie Albert to David Traub, ex-Commonwealth Commons, about what to say in hostage video, and Morrissey to Karen Reed and Turtle Boy judges that Jennifer McCabe is mad, no TRO. I'm sorry, I couldn't follow all of that, but this seems to have something to do with about this affidavit and about how there's being some sort of communications with the Alberts, Morrissey, And again, these are a lot of allegations that there's supposed to be some emails. I haven't seen any of these emails, and I know that Turtle Boy has a lot of connections, and maybe he talks about these things and he has them. I haven't seen them, and I like to base my opinion on what I see in court, what I see in filings, and all I've seen in that filing was the affidavit. I haven't seen any emails. I haven't seen any text messages. I haven't seen any call logs. I haven't seen any Cash App receipts. I haven't seen any of this stuff. So I can't comment about it until I see it in court, until we see it under cross-examination and all the rules of evidence and the rules of criminal procedure. That's how I like to base my opinion. I'm not a journalist. I'm a lawyer. So that's what I get my opinion from. Okay, let's move on a little bit to Carrie Roberts. Okay, so did you get to see some of the Carrie Roberts testimony?
Yeah, I saw a lot of it.
Okay, so essentially the takeaway that I got was the reason why they're calling Carrie Roberts was simply to say that earlier in the morning, 5 o'clock, 6 o'clock in the morning, is when she saw the taillight, and the taillight, she says, was not just cracked, but had a piece missing. And you saw the cross-examination. You heard about the cross-examination on Carrie Roberts. Tell me what you think about it.
I thought that I thought that Alan Jackson did a very good job cross-examining her. I thought that Hank Brennan did a nice job presenting her testimony. I was kind of wondering why she was testifying. You generally want to start with your strongest witnesses. I don't know if there's going to be stronger witnesses, but I would certainly want to start.
I will say, Solomon, this is a very important part of the case about when that taillight was missing. Because remember, right. So,
right. But I think that there's more questions about the taillight than anything else. And unless you're going to answer those questions, I don't think you're doing yourself any favors if you're the prosecutor. I was wondering why she was testifying at this stage in the case. I guess there's different theories of how to present witnesses. One is chronologically, and one is from strength to weakness. And obviously with different bullet points of what you're trying to get at. I thought that Alan Jackson did an excellent job calling into question her credibility.
Yeah, well, let's talk about her statements that she made to the grand jury and what she said today in court. The grand jury, she said to Adam Lalley's question about whether she heard Karen Reed tell Jennifer McCabe to do a Google search for how long to die in cold, she testified that she heard that. Right. And now she's saying, well, no, I didn't testify that I didn't mean that I heard that. I just mean that Jennifer McCabe told me that later.
Right. Now, I'll tell you why this was so powerful to me. If she made that mistake, own that you made the mistake. The way she refused to acknowledge it, she was arguing, kept saying, well, technically. And, this was, Alan Jackson kind of made another poke where he said, kind of pregnant. And the judge interjected, of course. I don't think there's anything wrong with the judge interjecting there, by the way. He still made the point that, she was refusing to acknowledge that she supposedly made a mistake and to, refuse to acknowledge that her statement was wrong. If you make a mistake, you got to acknowledge that you made a mistake. I don't know how well or if at all Hank Brennan prepared her as a witness. But I think this was very predictable cross-examination, and I don't think that she handled it very well. And frankly, I think that it's something that Hank Brennan should have done a better job bringing out. If you know there's going to be an attack, bring it out in your direct. It's as simple as that. Right. If there's something the jury's going to hear, they've got to hear it from you. Otherwise, the jury's conclusion will be you're hiding things from them. And there goes your credibility.
And if they keep seeing that it'll play over and over and over with all the witnesses, then I mean, like we know, the bad facts you got to bring out from your witnesses. So like when he's got Proctor on the stand, for example, first of all, we were talking about if the Commonwealth is going to call Proctor. So I've been saying from the beginning, they have to call Proctor, because if they don't call Proctor, the defense is going to call Proctor.
It's more than that. If the defense calls Proctor, and I'll do this a lot as a plaintiff. If I know I've got an adverse witness, whether it's a defendant or otherwise, that I can absolutely destroy, I'll call them first, and I won't let the defense know I'm calling them first. I'll start the trial by saying, we call defendant so-and-so. Now the defendant is, kind of caught off guard, gets up there in the witness stand, and then I get to go ground and pound. You said this. You said this. This is true. Here's a video clip. You testified to that. You gave a statement to this. And it's boom, boom, boom. And then you say, I'm done. Nothing further. And you sit down. You can obliterate an entire case by doing that. So if Michael Proctor gets called as a defense witness, then the first thing the jury's going to see, the only thing the jury's going to see, the first half hour that the jury's going to see is direct yes or no, ground and pound type questions from the defense, which is going to just make him look like an absolute liar.
Yeah,
and
terrible
it's
person.
it's not going to be good for the prosecution. The prosecution has to call him and present it as best as they possibly can. Let him tell, go ahead, explain to the jury who you are and how long you've been doing it and how great of a person you are, and tell us what happened with this particular case and why you sent this text message and what did you mean by it. At least you get to kind of couch it somewhat.
Right.
But
Exactly.
to ignore it just doesn't help you. I'd be shocked if the prosecutor does not call Michael Proctor. Absolutely shocked.
Right. So that's what I was saying. They have to call Michael Proctor, and they have to bring all this stuff out in the direct examination to try, at least at this point, even though the jury already heard from Alan Jackson, that's all they're thinking about for the next, until Proctor's called, which is probably why strategically they should probably just call Proctor already, instead of letting the jury sit on this information every single day, waiting. When are they going to call this guy Proctor? When are they going to call this guy Proctor? But anyway,
and by the way, I think the jury is probably doing that. I think the jury wants to hear from three people. They want to hear from Karen Reed. They're not going to. I don't think. Based on we'll have to see what happens with the case. I don't think there's a reason for her to testify. No. I think there's going to be so much reasonable doubt without her testimony. There's no reason for her to testify. But they want to hear from Brian Higgins. They want to hear from some of the Alberts, and they want to hear from Michael Proctor. That's all there is to it. That's what they want to hear from.
And they want to hear about the Google search. So, put that on.
Hear about the Google search. I think the first thing they should have done is call Mr. Albert. This is your home. What was going on there? Explain. Yeah. How did people not see John's body? You got if those are the things the jury's thinking about, you got to hit them head on. Yeah. You got to start strong. I think as a plaintiff, your first witness has to be dynamite. I think there's two super important witnesses when you're a plaintiff. Your first witness, you have to just blow the case up. And the first defense witness, you have to absolutely destroy. Those, I think, are the two most important witnesses of a case when you're the plaintiff. And in this case, obviously, the prosecutor is the plaintiff. I don't think I don't think he's doing that. No, like we said, I think we agree. Proctor's got to be called soon. Google search got to be called soon. Brian Albert's got to be called. I mean, that's what you should do if you're the prosecutor. Just get it out, because that's what the jury's thinking about. That's all they're thinking about. So put that stuff out, and then you get to the other witnesses and fine. Okay. Remember, I sent you, I don't know if you got a chance to see this, the DA Morrissey hostage video. That's what they're calling the hostage video. That was his statement that he gave to the public about the witnesses being forthcoming and truthful. You remember that that I sent you about? I don't think I saw that clip. I'm sorry. I remember it was the DA Morrissey who was talking about the investigation and the people that are involved. You don't remember that clip? Okay. I thought I may. Why don't you play it if you got it? I'm not going to pull it up now, but okay. Remind me what it said. Maybe I'll remember it if you describe it. He was just telling everybody in the public to stop harassing the witnesses. They're all being truthful. They're all being forthcoming. He never went in the house. You remember that? Now is it starting to jog your memory? Yes. You're talking about the prosecutor, the DA. Yeah. That 5-minute video. Exactly. So people want to get. Okay. People want to get your take on it. So hold on. People want to get your take, and I'm going to leave for 1 second, but go ahead. Give everybody your take. Okay. Okay. If this is the video I'm thinking of, and this is the one where I think I saw this like a month ago or something, several weeks ago at least. There are some major problems, and again, I don't remember it offhand, but I remember that he made a number of comments, but he left even more things out. When you're trying to persuade people a certain way, first of all, I think it's a big strategic mistake to try the case in the media. Okay, this is not a case that you want to try in the media, in my opinion. And by the DA doing that, you're almost presenting yourself in a way of, okay, I don't want to talk about it, but here's what I want to tell you about it. I don't want to answer questions about it, but here's the little bit I want to tell you about it. Okay, I don't want to be interviewed, but here's what I think you should know. And it's almost like it's exceptionally hypocritical to get up and say publicly, I'm not going to talk about the case, but let me tell you about the case, which is essentially what he did. And I've seen prosecutors do this in a number of cases where they want to get a few things out there because the defense could be out there saying things and they want to, address them. I don't think he did himself any favors. I don't think he did the prosecution any favors with that statement. I think he left too many things out. And I don't think it came across the way he intended it to. I just don't.
Yeah. Here, the other Karen, how will allegations be handled in the Karen Reed trial? And she's talking about the affidavit. So how's that going to be handled in the Karen Reed case? Well, nothing's been filed in the Karen Reed case. If they want to, if something ever comes out of this and there's actually some real misconduct and things like that, it actually bears out, well, then they're going to have to file a motion to dismiss. They're going to have to file for at least for a mistrial, right? I mean, that's how it would be handled in their case. What do you think, Solomon?
So if the things in this affidavit are true, then I think the prosecutor's got a number of major problems. If there's evidence supporting this that Karen Reed's attorneys get their hands on, then what will likely happen is they'll ask the judge for a sidebar or to address this not in the presence of the jury. And they'll tell the judge, I now have the following things. There's Brady violations in here. There's probable cause problems in here. And the fact of the matter is these things, if they're true, should have been disclosed to the defense at the very least. It sheds a lot of shade on the prosecution. And if there's actual evidence of these allegations in this affidavit, then the prosecutor is going to have a real problem. And I mean, even this judge may have to dismiss the case at that time. But who knows? There's too many ifs that surround this.
Okay, Elf, and if you have any more questions, please put them in the chat now. Elf, police never filed an accident report, never took a picture of murder weapon SUV taillight. Why?
It's a great question. I think I know the answer, but it's a great question. If it would show what the prosecutor wants it to show, there would be pictures of it. Just like if there were 46 broken pieces of taillight when they saw John's body, there would be pictures of them. Or there would be an EMT, not just saying, I hit him, but saying there were shards of glass all over, shards of taillight all over the place. Nobody says that.
Yeah.
46 pieces, that's a lot.
So we'll just talk about the last few witnesses before we let you go, Solomon. And I know I'm kind of like throwing you here, but throwing you to something that you're not familiar with. But the last two witnesses testified essentially to the following: that Karen Reed, because of the Section 12, they pulled her blood in the hospital setting. And the hospital, according to the hospital, they do a blood alcohol content test, and it came back as 93 milligrams per deciliter. And that's around 9 o'clock in the morning, 9:30 in the morning.
Whoa.
So there's going to be some testimony later on about what does that mean she was at 12:30 in the morning. Now, of course, there's going to be some, there can be some arguments about, well, maybe she drank later after she got home that night at 5 o'clock in the morning. So it doesn't really definitively show that that's how drunk she was at 12:30 in the morning when this, alleged accident happened or incident happened. But that's what this showed. Now, one of the points that were brought on cross-examination was the fact that this was done in a hospital setting, and the accreditation was different. It wasn't a forensically, it wasn't done in a forensic way, meaning that they did it with the serum instead of a whole blood. And, so therefore there can be some differences in the reliability of that test. But on cross-examination, it was like, yeah, the reliability is going to be a little bit off, but it's not going to be like, oh, it was really 10 milligrams per deciliter, not 93, so, like, is this actually going to work to try to make the case that she really wasn't at least over the limit at around 12 o'clock in the morning, without, I guess, some speculation that maybe she drank when she came home before going to sleep that night.
Right. So that's kind of where my head went with that too. If she didn't have anything else to drink from the time she got home till the time it was 0.093, then she was pretty darn drunk 5 hours earlier. And I
And
mean,
there's-
really darn drunk.
Oh yeah, I also do want to say that there's also some on cross-examination. There's some points brought out that someone who has MS and someone who's anemic also they can be a little inflated also. Or can
Oh
be
yeah,
seen.
that's true. That's
Yeah.
true. But still, I don't think that changes much. What this case ultimately is going to hinge on is Michael Proctor, the taillight, the cell phone video, the Albert family. I mean, whether she was drunk at the time, I don't think that's going to really. I don't think the case is ultimately going to hinge on that. I think
Yeah.
the
Yeah,
case is going to hinge on.
I've
the
been saying
credibility
if
of the
I've been
prosecutor's
saying if they would have charged her with DUI, then they would have had a good shot.
Oh, yeah.
But they charged her with also manslaughter as a result of DUI. So then they have to prove that there's an interaction between this car and John O'Keefe, and that's where the trouble begins.
Well,
Yeah.
something that my head keeps coming back to is if you hit a person with a car, there's going to be a mark on the body. If there's no mark on the body, how in the world do you establish beyond a reasonable doubt that she killed somebody with her car?
Yeah, exactly. Well,
kidding me?
again, the Commonwealth's theory here is that the taillight exploded on his arm, and that's what caused those abrasions on his arm. But no bruising, no contusions, no fractures, no torn ligaments, nothing else.
The
Just
claim that the abrasions on his arm were caused by a car hitting it are
exploding.
insulting. They're insulting to a jury. No, I'm telling you, it's almost that to me is almost like bringing a NASA scientist into court and trying to convince a jury that the Earth is flat. You just can't do it. You could have the best scientists in the world with a million initials after their name and an 80-page CV. It doesn't matter. If you're going to try to say something that's that insulting, you take one look at that arm. That was not caused by being hit by a car. It just wasn't.
Yeah. Well,
Common sense will tell you that. You don't need an expert for that.
yeah.
I mean,
Well,
they're
they're
going to
gonna
have
have an
experts,
expert.
obviously, but no. If you ask anybody of ordinary intelligence, was this caused by being hit by a car or by an animal? 100 out of 100 people who are not prosecuting this case or involved in the prosecution will say it's caused by an animal.
Yeah.
No,
All right.
it's true. I mean, that's
Yeah. Honestly, that's why, like, I think it's also so important. I spoke about this. It's so important to stress to the jury not to just leave their common sense at the door. You're
Right.
going to be hearing a lot of expert witnesses, and everyone's going to be talking about science and this and equations. Don't leave your common sense at the door. Look at that picture, and what does your common sense tell you? Okay.
I think
Nina
Alan
Stanek-
Jackson will address that in his closing.
Yeah.
I think
Nina
Brendan
Stanek says, if the defense calls prosecution witnesses, would they automatically be treated as hostile?
Good question. Okay, so that's obviously somebody who's familiar with the rules of evidence. Yeah, the way it works is you can't ask leading questions to your own witnesses unless they're adverse or hostile witnesses. I just had this in a very recent case where in my case in chief, I called the defendant, and I started asking leading questions, and the defense attorney objected that I was leading. And I just kind of looked at the judge and said, isn't this a hostile witness? And the judge shot it down very quickly. He looked at the defense attorney, goes, you think he planned this testimony and he's leading the witness? It's like, is that really where you're going with this? And she very quickly withdrew her objection and sat down. Again, if there's any judge who would make such an absurd ruling, maybe this is it. But I would certainly hope that if it's a prosecutor's witness or a police witness that's adverse to you, that you'd be allowed to ask leading questions. I'd be shocked if they're not allowed to.
Yeah, of course. Yeah, of course, that proctor's going to be considered an adverse witness.
I would
Here's
certainly
another.
hope so.
Yeah.
I would certainly hope so.
Here's Kelly. If Chloe bit, you must acquit. Did you see the rock that was put on the yard of 34 Fairview for the jury view that was painted Alberts and appeared to have red on it? It was never there before. That's jury tampering, right? Well, apparently there's a view, and there's some questions about a rock being placed there, which said something about the Alberts. So is that jury tampering by putting something in the view that shouldn't have been there?
Where was it? In the courtroom or somewhere else?
No. They went on this view. They went to view 34 Fairview. And this rock, what they're saying, I haven't seen this yet.
One second. They took the jury on a road trip?
Yeah, they took the jury to look at the scene at 34
Nice.
Fairview.
Wow. That's very rare.
And yeah, so at that scene, at the 34 Fairview, this is what Kelly's telling us, is that there was a rock that was placed, apparently, this is the allegations. I don't know any of this, but I'm just saying what Kelly wrote, that there was a rock that was placed there that said Alberts and appeared to have red on it.
That could be. I mean, when I think jury tampering, I'm thinking more in terms of bribing, threatening, coercing an actual juror. Would this be jury tampering? I don't know if it'd be tampering. It would certainly be problematic. If there's somebody who does that intentionally, they're certainly trying to persuade the jury, I think. I mean, that's not a smart thing to do. If somebody did that, they can be held in contempt or charged criminally potentially.
Yeah. Here's another from Baby Fishes. The affidavit from Turtle Boy on Friday relates to the DA making that video. Turtle Boy has impounded text messages as receipts for the affidavit. So they're impounded. We don't get to see it. So
okay. Look, if they're there, they're there. If there's either going to be evidence supporting these claims or not. If there's evidence supporting these claims, prosecution has a real problem. Real problem. If there's no evidence, it's just allegations. In a case like this, there's going to be all kinds of people making all kinds of allegations. So until we have more, there's just no reason to even talk about the affidavit.
Okay, and then we'll get to one more comment. It doesn't look like there's some more here, and I know Solomon's got to go soon. So from DJ, shout out to Brothers Counsel and Solomon. Great analysis, gentlemen. Thank you very much for joining us. Okay, so Solomon, I know that you're on a ticker. I know you're running out and have a big week ahead of you. We have a big week here following the Karen Reed, and I hope that you'll be back over the weekend so we can talk about the case a little bit and bring up some issues so that we can do this again maybe next week. So, but I think that's going to be it for today. Thank you very much for your time, Solomon. Let me just remove you from the video so I can just give a last little talk to these wonderful people who came out to see us today. So thank you all for coming. It's very much appreciated. We will be live streaming again tomorrow. Monday is going to be so important, a very important day in the trial. So join us tomorrow here. Brother Counsel Studios will be live streaming it. I actually have a hearing in the middle of the day, so I'll have to step away for a little bit. But the rest of the day, I should be able to join you. And then we're going to have, the ARCA witnesses testifying in the afternoon, the voir dire. So half a day of trial, half a day of voir dire for the ARCA witnesses. Maybe we'll see some of those text messages that Alan Jackson was talking about that were deleted in due course, according to Robert Alessi. So maybe we'll see some of those text messages. We'll see what the ARCA witnesses have to say. So it's going to be a very interesting day tomorrow. Definitely join us here. Of course, we're going to do the best to do our recaps as we're always doing throughout this trial. And that's going to be it. So thank you all for joining us today, and we will see you next time. Have a great week, and we'll see you tomorrow.